right, everybody, good morning. We're going to get started. Appreciate all of you being here. My name is Steve McDonald. I'm the county manager here at Shoots Title. I want to welcome all of you. Got a special speaker today, Commissioner Steve Strode. He wants to do his own bio, so I'm going to let him do that. But he did want me to mention that he is now a resident of Bend. So, we're for a good class. We'll turn that background music off, and without further ado, here's Mr. Strode. All right. Am I coming through okay? Yeah. Okay, great. All right. So, well, all right. Well, welcome. Thank you for having me this morning. I really appreciate being here. This is a course that I first gave at the Oregon Realtors Fall Conference in September or so. And so it's my second time giving the class. I'm still looking for feedback. So if you have any suggestions at the end, by all means, share those with me. So, just a little bit about our roadmap for today. And first, the point of the course is I wanted to create a course that describes what is it we do and kind of demystifies the process when it comes to investigations and regulations and things like that. And at the same time, I want to make you less nervous if a complaint does come in against you. So the personal side of that as well. And then I also want to share some changes we've implemented the last 4 years since I started this position, and then the results of those changes. So just a quick bit about me. I started this role in February of 2019, and prior to that, I did serve as one term as Oregon Realtors President in 2018. And before that, I was in a number of volunteer leadership roles, like a number of you in this room, both at the National Association of Realtors and at the state and local level. So I got it listed up there. I was first licensed in Wisconsin in 2001. Then we moved out here in 2008. I was licensed from 2008 until 2019. Anybody who joins the real estate agency who is a licensee must put their license on hold while they work with the agency. And that's kind of separates the regulator from the regulated. And so you keep that firewall. So I no longer have my license in Oregon. If I was to leave this position, I could be licensed again if I wanted. So I first want to talk about who's who in the process if a complaint comes in. There's a number of players, and one, of course, is the complainant. That's the person who files a complaint against a licensee or an individual. The respondent, that's the person who the complaint is against. And that could be either a licensee or a non-licensee. Some of the complaints you may see are people that are, there's a complaint that are operating unlicensed activity, so that would be an unlicensed individual. And then we have the investigator, of course, and our compliance specialist. Our compliance specialists are those who review the incoming complaint, and they will close out them if there's no jurisdiction, or there's also a compliance specialist who drafts all the orders. How many of you read the Oregon Real Estate News Journal? You think that you know? Okay, so most all of you know. Okay, so pretty much this whole room understands the outcome. You've seen those in orange. And then the regulations manager, that of course is the person who's responsible for leading and the performance of the division. And they interact a lot with the compliance coordinators and me as the commissioner. If a complaint goes to the Office of Administrative Hearings, and I'll talk about that more later, then we're represented by an Assistant Attorney General, and the case is heard before an administrative law judge. Most of our cases are resolved before getting to that point, but it is everyone's right to have a hearing if they so choose. I was going to say, too, if you have any questions during this, just raise your hand. We've got time. I can adjust the pace of the presentation accordingly. So I'd rather you ask questions when they're top of mind. Okay, so the mission of our agency, and that is to provide quality protection for Oregon consumers of real estate, escrow, and land development services, balanced with a professional environment conducive to a healthy real estate market atmosphere. So that's, I know it's a mouthful. And then in our regulation division, their mission is to conduct fact-based, unbiased investigations, and if warranted, propose disciplinary action through the administrative process. Everything we do at the agency is defined by statute and rule. So if it's not in statute or rule, we don't have the authority to act. So generally, and this exists for all occupational licenses, the overall concept, overall rule guidelines are in statute, and then the operating guidelines may often exist in rule. Statute can only be changed through the legislative process, and then we can change our rules through work groups and public hearings and things like that. So as an example, we went through some licensing, advertising guideline changes a couple of years ago. Those we were able to change through rulemaking, not through statute. We had a work group we put together, and that's all through rule. So my guiding statute is OREA 696396. The real estate commissioner shall provide by rule for the progressive discipline of real estate licensees and an objective method for investigating alleging grounds for discipline under OREA 696301. So quick question, how many of you know, or maybe you know how many grounds there are for discipline? Big guess. It's a big number. I kind of hope you don't know the way. There are 15. And so I'm going to step out here. So what I have on here is right from OREA 696301. And these are the reasons. I bolded the ones that we see most often as reasons for discipline. One, create a reasonable probability of damage or injury to a person by making one or more material representations or false promises. Skipping down to number 4, knowing or recklessly published material misleading or untruthful advertising. Number 11, been convicted of a felony or misdemeanor substantially related to the real estate licensee's trustworthiness or competence to engage in professional real estate activity. Number 12, demonstrated incompetence or untrustworthiness in performing any act for which the real estate licensee is required to hold the license. And then 14, committed an act of fraud or engaged in dishonest conduct substantially related to the fitness of the applicant or real estate licensee. And then one that's somewhat of a catch-all, but is, you probably see this quite a bit, engaged in any conduct that is below the standard of care. Okay, so about the complaint process. I should do this on this. The screen's so high now. I'm sitting here. Okay, so incoming complaints. So we receive a complaint from a licensee or a consumer. We first review it for jurisdiction and have all the proper documentation. Sometimes we get complaints that are really not under our jurisdiction. For example, if it deals with landlord-tenant law or a fair housing violation. Fair housing violations are first investigated by BOLI, Bureau of Labor and Industries. Thank you, whoever said that for me. Thank you. So if there's no jurisdiction, we will close it as well. Or actually, in the case of a fair housing complaint, we will forward that to BOLI directly. We want to facilitate that process. If BOLI finds out that there was a fair housing violation that involves a licensee, it could come back to us and we'll open our own investigation. The next thing we will do if a complaint comes in is we ask for a response. There's two sides to every story, and we want to hear your side of the story. I won't ask if anybody in this room has been named a complaint before, but if you're willing to share your experience, you're more than welcome to. We ask for a response. Again, there's two sides of the story. More than half of the complaints that come in do get closed for no violation. So again, I know it's intimidating, or you might be worried, oh my gosh, I'm under investigation. Respond to the complaint with all the detail you have, and we'll look at it. If it's a very minor infraction, we may just issue an education letter of advice right off the front. A good example of that is advertising violations. Your first advertising violation, we will point out the statute and rules that apply and send out an educational advice. If it's more serious than that, and we think that there is grounds for possible violation, we'll open the investigation. And then if it's clear from your response that there is no, we'll close it right away. Okay, so that's the general process. And we'll get into more detail on this in a little bit. Okay, some of this has changed in the last couple of years. First of all, we want to, the investigator will look at the initial case when it first comes in and really prioritize and determine what their next steps would be. In the past, we used to employ a process of first in, first out. And what that could mean was it could be several months before a very minor complaint would get looked at. So now we try to prioritize it better. So if it's a real simple investigation or simple case, we will try to get those worked through more quickly. I already gave that one example of the advertising violation. If it's a high priority case, we will put that to the front of the queue. A good example of that are property management cases that allege mishandling of funds. If we're concerned that a property manager is taking off with the money or something like that, we will make it a high priority because there's direct consumer impact. Standard priority would be cases or examples where, let's say the transaction is already closed and a consumer or a licensee is complaining about something that happened during the transaction. That would be more of a standard priority. You know, we're not concerned about ongoing theft. One thing I want to make clear is that the investigator is not out to determine if a violation has happened or not. Their role is really just to determine facts. So in their investigative report, they will not offer opinions either in the report or when interacting with the complainant or respondent. That is for me to decide if there's a violation or not. So really, we want the report to be as objective as possible. And that is outlined in the rule, or OER 863017010. You can look at the website and read that in its entirety. So again, that part of the process is totally objective. There's no decision making in the investigative process. Another thing we get occasionally, and if you looked at, if you read the last OREA, I mentioned this as well. We sometimes get hypothetical calls about, hey, this licensee is doing X, Y, and Z. Is that a violation? And I respected the question in that sometimes the licensee just wants to work it out with another licensee and just say, hey, I talked to the agency, what you're doing is wrong, please stop it. Otherwise, I will complain. We have to stay away from that because, again, what I referenced before is there are both sides of the story. And sometimes, if we were to make a determination based on that phone call, we only know one side of the story. And that licensee might go back to the other individual and say, knock it off, and just said it wrong. Well, that's not fair because we don't have all the facts. So we cannot respond to those hypotheticals. What we will do is we will try to point you, if you're calling, to the appropriate statute or rule, and then encourage you that if you think there is a violation, please file a complaint. We will look at it objectively and determine at that point. We'll also often recommend you contact an attorney because even though we have like this legal authority in terms of enforcing statute and rule, we are not attorneys and we cannot offer legal advice. It's the same thing you have in your own transactions when you say, you know, I can't tell you the outcome of what happens if you do X, Y, Z. Yes.
I'm curious how many like investigators you have or how many people you have working on this.
And I'll repeat the questions because we don't have like something right now. We have 9 investigators total. The question is how many investigators we have. And we're all on a hybrid work model. You mentioned it throughout the state. That's a good point for me to bring up. We are no longer doing site visits for investigations. we know your business has changed. You don't operate in an office where you have all your file drawers, everything's electronic. So we operate in a hybrid environment, and so all the investigations are conducted virtually through Zoom or through phone call. One thing about that too is it enables us to hire staff more broadly as well, because we can reach the entire state. I've got investigators that do not live just in Salem anymore. So it's great from a recruitment standpoint too. All right. So this is one area where we've really tried to improve in the last several years, and that is better accountability. In the past, like I said, we used to work the cases first in, first out, we get to them when we get to them, and we didn't prioritize our work as well as we could. So now we have what we call these accountability check-ins, and the investigator will meet with the lead investigator, also called the compliance coordinator, within 14 days. And that is to really prioritize the cases. You agree on strategy, scope of the investigation, estimated time frame. Really, it's similar to, you know, if you're training, you have a coach, or you're training for a race, and you have an accountability partner, you're training for a marathon, things like that. Having those regular check-ins, keep things on track, keep people accountable. At 60 days, we'll have another check-in if the case is not complete, understand where we're at with the case, then reevaluate the timeline if necessary, because if we thought it was an easy case, it's going to take 4 months or 5 months more, we may need to take some work off that investigator to give to someone else so it doesn't sit and get stale. So they were constantly reprioritizing that work if necessary. In 90 days, that's getting towards our goal. Our goal is to complete all in 120 days of intake. So if we're getting 90 days, we're going to start to be concerned. Are there other things we need to look at? Is there something with the case that's difficult? Are there barriers involved? And then if after 90 days, the case is not done, we follow up every 2 weeks. So again, why am I sharing this? It's because I compared it to our process before, and that was first in, first out, and there wasn't the priority of cases. And I think it's really important to talk about this because it does show up in our results. In 2021, our average days for investigation completion was 148 days. Last year was 65. And then for our investigator ranges, meaning how they all perform individually, in 2021, they ranged from 88 days to 229 days. Now our range is 42 to 85. We're not skipping on the work. We're not doing less work. It's a matter of having those accountability check-ins and really having that coach with the investigator to make sure things are on track and working through barriers that come up. So I'm really proud of these results. And again, it's not compromising the quality of our work. I make sure that our compliance coordinators do review the investigative reports for quality and things like that. So a report completion. So the scope of the investigation is limited to the initial complaint. We don't go out on fishing expeditions to look for, oh, what else did they do wrong? Let me show me all your files for the last 3 years. We don't do that unless we have a reason to believe there really is something else egregious going on. But the scope of our investigation is limited to the complaint, again, unless it's extended by me. That only comes at my permission. The reports are objective and they don't include conclusions or recommendations or editorials and things like that. All of those reports are then submitted to a compliance coordinator, basically a lead investigator, to review for completeness and accuracy. The reason that's important is because if this case goes to a hearing, the ALJ, the administrative law judge, is going to look at the quality of the investigation, make sure all the I's are dotted and T's are crossed. So once the report is done, then there's an administrative review with the compliance coordinator myself. I'm describing this process in this way just to really convey the fact that there is, again, this firewall between the investigator and the commissioner. Another difference would be in the past, the investigator would sit with the regulation manager and the commissioner to talk about the outcome of the case. And I don't want the investigator to have like this personal stake in the outcome. It's not their job. Just like, you know, the police officer doesn't sit with the judge and talk about the case. So a little bit about what is the purpose of progressive discipline, because I know there's sometimes some confusion about that, and sometimes I get questions about why did the agency land where it landed. So it's really important to understand what is the goal of progressive discipline. The goal of progressive discipline is to correct a licensee's inappropriate behavior, deter the licensee from repeating the conduct, and educate the licensee to improve compliance with applicable statute and rules. Progressive discipline means the process the agency follows, which may include using increasingly severe steps or measures against a licensee when a licensee fails to correct inappropriate behavior, like so the subsequent instances of inappropriate behavior. Now, clearly it's written by attorneys. But it's really important to summarize that. It is our goal, if there's an infraction, is to correct the behavior, go about your business, and don't make that mistake again. That's really the goal of progressive discipline. So, and there are exceptions to that. If everybody raises their hand while reading the OREA, you will notice that sometimes we go straight to revocation. I'll talk more about that in a little bit. So here are the outcomes, and who has authority to make those outcomes. So if there's no action, our compliance coordinator can just close out the case and then say there's no violation. If you read statute, it always says the commissioner shall, the commissioner shall, the commissioner shall. We have a delegation of authority to engage in certain, do certain things in the agency. One is to close out a case. I've delegated that authority to the compliance coordinators. So if they determine that there's no violation, that doesn't have to come to me. And that's just from an efficiency standpoint. If I had to look at all 600 cases in a given year, we would just not be as efficient. That outcome is communicated to both the complainant and the respondent. So if you ever complain against another licensee, you will be copied on the outcome if there's no violation of time. It will say in the letter, if there's additional information that we may consider, we'll reopen the case. Perhaps we didn't get everything from the complainant first time around. They had second thoughts about sharing something, that type of thing. We can reopen the case. Education letters of advice, again, it says in statute that's the commissioner's authority. I do delegate that to the compliance coordinator, so he or she can send out. So he or she can send out an education letters of advice. If there's an administrative action, that all has to come through the commissioner's office. So the types of administrative actions are reprimands, suspensions, revocations, and the next column, civil penalties. So again, I sign off on all those. The last column is civil penalty. That's for unlicensed activity, escrow violations, and also we employed this a number of times recently. Failure to respond from the agency for a records request. We are running into a situation in the past, and it also why our cases took longer, is if the respondent just ghosted us and didn't respond, we would sometimes wait a long time, like let's give it another chance, let's give it some more time. We stick to our timelines better than we did in the past because there's really no reason not to respond to us, except for like during COVID, we had issues like that. You know, we're human, we understand that. So if there's an illness or things like that, we have recognized missed deadlines. But if they just don't respond to us, they ghost us. I can think of several examples where they moved out of state, but I'm done with you guys. Yeah, I'll ignore you. Forgetting that if they're licensed somewhere else, our administrative action can haunt them on their renewal somewhere else too. So they have that wake up moment. Okay, so again, those are all approved by the commission. kind of talked about this already, it's kind of just restating what Aaron said. One thing I want to touch on this slide is we will look at prior administrative actions as well in determining an outcome. Again, a progressive discipline means if you were reprimanded for something in the past, the issue is before us again, the next step could be suspension, or if it's truly egregious, it could be revocation. So that's the progressive discipline part of it. So we look at historic prior administrative actions. Also, it's really important for us to be consistent with historical practices. So if we gave a reprimand for this failure to disclose on 5 other cases, well, that could be the appropriate outcome in this case as well. So we need to have consistency. Again, 2 paths: education letter or legal fee. I want to talk about the education letters a bit because, again, that's the first step in the process. It's not considered an administrative action, therefore they're not in the OREA. So I think there's sometimes this misperception that if we file this complaint, the agency does nothing about it anyway. You know, I never saw anything about it in the OREA. That's not necessarily true. Remember, progressive discipline is to correct the behavior. If we send an education letter out to the respondent, they correct their behavior and it never happens again, that means that the process worked. It's really important that you send the complaints in if you think it's serious. Advertising violations, like I said before, are a common one. The licensee did something wrong, they fix it, and it never happens again. We will copy the complainant, however. So if you are the person complaining, you'll know that the outcome was an education letter device. So in 2021, we issued 75 education letters of advice. In 2022, we issued 99. So I don't think there's an increase in complaints coming in necessarily. It's more that we're trying to process our work more efficiently. And so we're not carrying this workload over into 2023 like we may have in years past. I touched upon this already, and that is if the compliance coordinator, after reviewing the investigative report, determines that there could be a violation, then I set up a meeting with either Megan or Henny, with the two leads, Megan or Henny, and we will determine if an administrative action is appropriate. They will bring all the supporting evidence to our meeting. They will research prior examples of similar administrative actions that we may have issued in the past. And then we generally come to agreement. Sometimes I recommend an alternative. And then if we decide we're going to issue an administrative action, this is when the process now kicks in. So following that meeting, the first thing we do is send out a settlement offer. And that's where we will share the investigative report, share what we believe the violations are, and also propose our outcome. So is it a reprimand? Is it a suspension? Is it a civil penalty? So we'll send out that letter. We'll give them instructions on how to make a records request. So if they want to see all the exhibits that came in, we will give instructions on how to get a copy of that. So this is, even though it doesn't feel like it, this is an informal part of the process. It's not an administrative process through the courts. It is still considered an informal process. The respondent may accept our offer in this settlement letter, sign off on it, agree to it, and then it ends up being generated. And those are the ones that get published. They may wish to meet with us informally and really bring more information to the settlement conference. Maybe they have additional documentation that they found that they couldn't find before. They want to talk more about maybe what they're going to do personally at the time, whatever the case may be. So we will then have a settlement conference meeting. And then that's all done with DocuSign. When I started, this was all done through snail mail, and it took extra time. And, having been a realtor, I know that there's DocuSign or something like DocuSign. The only thing I cannot do by DocuSign, I believe, is a revocation. Something still need to be set up by mail. So this is describing the outcomes. We we really try to be fair in what we're proposing in the settlement outcome. I heard anecdotally that in the past, sometimes the agency would go out with a higher proposal than where they expected to land, just so the respondent felt like they negotiated back and forth and, just like all real estate, you're pushing a better deal. I don't take that approach anymore because, number one, I want the outcome to stand on its own. I don't think it should be the result of better negotiating, or if the respondent hires an attorney, some folks can afford an attorney, some cannot. Our outcome shouldn't be predicated on whether or not the legal representation. So we've seen an increased trend in people accepting the settlement offer on the front end. So in 2021, that list, we had 17 accepted offers, which is a little bit less than half, 6 reprimands, 3 suspensions, and 5 civil penalties. In 2022, that has increased. I'm trying to get the message out there that we're trying to be fair. We're not trying to negotiate back and forth and propose a suspension when we really only want to do a reprimand. I want to be transparent with our process. So last year, about 3/4 of the respondents accepted what was in the offer. So 12 reprimands, 4 suspensions, 6 revocations, 14 civil penalties, and 3 limited licenses. At the settlement conference, that's conducted with the compliance coordinator, basically the lead investigator, and the investigator. That's where somebody, if they want to hire an attorney, more than welcome to. Some cases are more complex. We want people to feel comfortable in the process, so they may have an attorney present, discuss the findings, and again, I mentioned this before, they can bring mitigating information to the settlement conference or documentation. If somebody brings good mitigating information, that is an instance where we may lower our proposed sanction because something valuable was brought up that was not in the investigative report. So this shows our trends. In 2020, attorney representation versus without, 39% with. In 2020, 61% without. In 2021, we had 19% with attorneys, 81% without. In 2022, we had 12% with attorneys and 88% without. So again, trying to get that message out there. We want people to have representation if they feel it's appropriate. I would never deter that. But if it's a straightforward case, consistent with everything else you've seen in the OREA for the last 15 years, accept it, move on. It's kind of my approach. It's like, this is what happened. The facts speak for themselves. Reprimand is a reprimand, don't do it again. Okay, so if we cannot come to an agreement at the settlement conference, then the respondent can ask for a hearing through the Office of Administrative Hearings. That is where the process then becomes formal. Settlement conference, informal, Office of Administrative Hearings, formal. In this case, then we are represented by an Assistant Attorney General who then handles the case from here on out. So I would not be present to argue our case, rather the attorneys presenting it for us. In 2020, we had 7 hearing requests. 2021, we had 6, and 6 in 2022. I don't think that's the final number I think that's towards the 4th quarter. And then one thing I've seen recently that I'm not quite sure of why it's happening is the respondent asks for a hearing. They go through the entire process, in many cases, hiring an attorney, go through a pre-hearing conference. The agency spends a lot of money getting ready for the hearing because we have the attorney involved. And then they withdraw their hearing request or a no-show. And if they withdraw the request, we go back to our original proposed outcome. And if they're a no-show, we go back to our original proposed outcome. So this is one thing that I'm sharing because there's a budget implication for this. We spend a lot of money on attorney's fees with DOJ that may not end up in a hearing. And so again, I want to get the message out that we're trying to be fair. If the outcome appears fair in the settlement conference, you're more than welcome to accept it because that's generally how things land. But again, we're still trying to figure out why this is happening anymore. Don't have an answer for you. If I'm invited back, maybe next time we'll talk about this again. Yeah, go ahead.
With the number of hearing requests, do you have numbers like how many of those come from settlement conference that involve attorneys?
I'll just break it out one layer more.
Just
He was asking if I had a breakout of like how many of those come from.
Like the settlement conference, so many are represented by attorneys, so many are not. And then it goes to this next step, that next step where there's how many of those are.
Okay, yeah, so if it goes from the settlement conference to a hearing, how many of those that end up being no-shows or withdraws, how many of those folks are represented by an attorney? Anecdotally, I would say most of them. Yeah, so perhaps they had advice that we'll try and then they get further down the process and realize, yeah, this is consistent. That's a good question because it might tie into when the attorney was brought into the process too. They might not have been brought into the process until after the settlement conference. I don't know that for sure, but I do know, again, anecdotally, most often they have an attorney because it's then a discussion between the attorney and our AG where they may either withdraw. Yeah, so I think that's a really good observation. All right, so the next part is if again, if the respondent chooses to go to a hearing, then they can go to Office of Administrative Hearings. So far, we've had 0 adverse decisions against us from OAH, meaning of everyone who did request a hearing, 100% of them, those cases, the judge agreed with us. So I'm glad that's the case. Because I hate to fight this battle and then realize, oh, we're I mean, that would just show that I'm not applying the law consistently and appropriately. So again, 100% have been in our favor. But again, if that does happen, it's a human process, just like you're having a human process when you make mistakes. If something is an opinion against us, we'll use that as an opportunity to learn. If at the Office of Administrative Hearings, one of either the complainant or the respondent doesn't agree with the ALJ, does not agree with the judge, we then have a right to appeal it to the Court of Appeals. That is very rare. I can think of one that I've signed since starting in my role, or actually went to the Court of Appeals. I'm going to talk about that a little bit because it really shows you the high bar that is set to take away someone's occupation, to take away someone's license. Again, when theft is involved, and it's pretty cut and dry, you stole money, you lose your license. But when it's resulting from errors that you make in a transaction, either oversight or just really reckless behavior, there's a very high bar to take your license away. It's because, again, we employ progressive discipline. So I'm going to do some reading on this one here. This is a case where we proposed, and this was under the prior commissioner, proposed to take a person's license away, and the respondent exercised his rights to take it to a hearing. The court found that our proposed action to take away the license was excessive, and they reduced it to a 1-year suspension. So I'm going to talk about that case again, but it illustrates the high bar. Okay, I think I have a reading here probably. First, let me talk a little bit about the case was. All right, so this case, and you can look it up on our website. It's from 2019. You go under disciplinary actions, 2019. Christopher Robert Fox, and this was a case where he was also the seller, and there were some obviously big mistakes made in the transaction, and the judge said no, to take away the license is excessive. So I'm going to read some of this here. This is all from the appeals case, and then we incorporated this into our hearing. So I put it in bold. Licensee failed to include zoning issues in the land division violation, which were relevant data affecting the potential use and/or development of the property in the published promotional materials. Likewise, licensee failed to mark the appropriate boxes and complete the required disclosures in the sales agreement, reference the seller to, and warranty deed. Licensee also failed to report the adverse arbitration award to the agency within the required time limit. You know, if you have a judgment against you, you got to report it to the agency within X number of days. So he didn't do any of those things. The next bold part: the Court of Appeals did not determine that the licensee's conduct rose to the level of deception, but agreed that the licensee's conduct was reckless. They're making a distinction between deception and reckless. Then they also look at history. The licensee has never been the subject of any disciplinary action in Oregon or Washington. He's been active and licensed in both states for a lengthy period of time. He has a high reputation in the industry for ethics and knowledge. Skipping ahead a little bit, extensive experience, but not in the particular type of transaction that resulted in the proposed agency disciplinary action. Meaning, a lot of experience. In this case, he operated outside of his area of expertise. He has a reputation for competence in real estate. So all those things said, bottom line, a sanction of 1 year suspension is appropriate. So that really shows you that there's significant financial harm to the consumer. A lot of mistakes were made, but to take away a person's occupation forever, the court decided was excessive. The reason I bring up that case is we had another one where, and I'll talk about it in a little bit, where somewhat analogous, but the licensee took some steps to make the consumer whole, and I issued a suspension in that case. I actually had some fault on that one, saying, why did you suspend and not take the person's license away? This is the bar that's been set. Okay, I'm going to skip really quickly over these two, so I can talk about a few cases. So, background checks, fitness determination, those do not end up in the OREA. If I deny someone's license, does not end up in the OREA because it contains confidential information that's in the law enforcement data system. So they don't end up being published. But I do look at things like the passage of time since the crime was committed. Was your probation? Was probation completed successfully? Things like that. Drug and alcohol abuse does factor in quite a bit nowadays. The judges, the courts really expect occupational licensing boards to look at the fact that the person's recovered, things like that. So background check, and skip over this quickly. I wrote about this in the September OREA. There are other types of administrative actions that don't end up with a publication. We are required to suspend a license if another agency tells us they have unpaid child support. We have no decision making in that. They just tell us we will do it. And then also, then it gets unsuspended once they clear the application. And one more thing, back taxes. Is it on the slide or the slide? Oh, city tax. Okay, so if a licensee has not paid their taxes, we occasionally get a notice from Department of Revenue that says you will suspend this person's license until they pay up the taxes. Now, this is not you missed your quarterly payments. You know, we've all done this is when you haven't filed taxes for a period of time, and there's a judgment against you. And I know in one case the licensee said, "Well, how am I supposed to pay my taxes if you took my license away?" And if it gets to that point where you've not paid for that many years or hasn't had that much unpaid taxes, the courts have decided if you were going to use your income to pay your taxes, you would have done it by now. So it's no longer valid reason. You can't say, I can't pay my taxes. You gotta find someone to do. Okay, these are very rare. So I really want to scare you with this one. I've signed maybe 4 or 5 of these in the last 4 years. So these are for egregious issues with back taxes. Okay, so I want to talk, so we started at 9:05, so I've got some time here. Okay, I want to talk about some cases to kind of put this in, give you some examples. I'm not going to talk about the respondent's name. You can look these all up. They've already been published in the OREA already. So I really want to give you some perspective on why I landed where I landed. And so let's see here. Unlicensed activity. Number one, have you heard that the penalty for unlicensed activity has gone up as of January 1st? See if you had noted. The legislature last session introduced a bill to raise the minimum. I think it's 1,000 now. I should know that, but it just took effect. Actually, our representative from Prineville introduced that bill. So Vicki Iverson. So she's a licensee. Oh, go ahead.
Before you go through these
Yeah.
cases, I'm curious to know how often the respondent knows who filed the complaint.
Always.
They always do, even if it's just advertising, something like that.
Yeah, I'm glad you asked that. The question was, does the respondent always know who the complaint was? And the answer is yes. We've been asked why we don't allow for anonymous complaints. And the reason we don't is because there's already this perception, especially in advertising violations, that the agency does nothing about it. And so we want at least the complainant to know we looked at it and responded, this is the outcome. And it's just transparent. We're expected to be transparent in everything we do. We're a public agency. So if we allowed anonymous complaints, the person would just have to do a records request and see where the email came from. So it's not really anonymous anyway. I'm glad you asked that. Yeah, thanks. You know, it also says in our complaint process that we encourage licensees to work things out between themselves up front. So in most cases, you've already tried to talk to that person. Yeah. Okay, so a few cases. We'll talk about unlicensed activity, reprimands, suspensions, limited license, and revocations. So I'm going to talk generically about a few of these cases just to describe what happened. One was a recent civil penalty where I only issued a $100 fine. It's a case where an employee was hired by somebody who just didn't know he was supposed to have a license. He was told, no, it's fine, you don't need a license. And so in that case, he wasn't willfully doing something wrong. As soon as he found out, he was like, apologize. Okay, I'll stop doing this. So I issued a very low penalty on that one. Another one was where a licensee failed to renew, and he went for several months with an expired license. In that case, he was dealing with sick family member. This is during COVID, I think it was, and dealing with a sick family member who ultimately passed away. You know, I'm not going to issue the high end of the fine for that. So I issued $600. It could have been, I think, several $1,000s, but again, it was a bad situation, but he accepted it and moved forward. On the higher end, we had 2 property managers working together who had been working a number of doors, and for quite some time, they knew what they're doing was wrong, and I issued them both a $3,500 penalty, so the total of $7,000. So that's on the higher end. Again, it's all based on the circumstances. For reprimands, I can think of one, I think actually, might have been essential work into. This is one where there's a criminal trespassing charge where the licensee was considering buying the property for himself. He told the sheriff he was a broker. He didn't realize the property was occupied, fully acknowledged he screwed up, and the court just issued a small fine of $200 and some community service. So knowing how the court handled it, I issued a reprimand. It was considered a small violation. If the courts do not see it as a big violation, nor would I. So I issued a reprimand, move forward. Suspension. This is the one where I got some pushback. It is one where a property had a sale fail. The licensee was part of the LLC who owned the property. There were some issues identified on the first sale that were not disclosed to the second buyer. The buyer closed, and later some rainstorms caused the land to wash away this coast, I believe. So in this case, I issued a suspension, not a revocation, even though there's some serious damage to the home and some really bad missteps by the licensee. The details in this case were some mitigating information. The licensee worked with a family member to buy back the property from the complainant and made them whole. So they did everything they could, excuse me, to undo what they did wrong. So in that case, I issued a suspension, not a permanent revocation. Especially through the view of the Christopher Fox case, where that's a very high bar to take the license away. In this case, they took some steps. A limited license. So I can issue a limited license on an initial application. So if a person has some criminal background, let's say, for example, it's a criminal background, and I want them to have inability to do property management, for example. I can make that requirement from a new license. Once a person is licensed, I don't have the authority to limit their license through administrative action. They have to agree to it. What I have done though is we've gotten to this point through the settlement process to end up with a limited license instead of a suspension or instead of a revocation. So there are two examples recently where they agreed to it. Again, it was they proposed it to us and we agreed. One was recently where the licensee was not properly supervising his brokers at his office. And there was also some inappropriate behavior. It was related to alcohol addiction. Excuse me. And so there was some other stuff going on in this person's life. He took responsibility for it. And so now he has a limited license for 3 years. We cannot supervise any other licensees. And we cannot require any kind of treatment, like alcohol treatment, drug treatment. That's not within our authority. They can offer it up. So again, here's a limited license for 3 years, and we hope this person gets better. The second one, again, these are all in Orange. The licensee was caught on video going through the seller's personal belongings in the garage, the medicine cabinet or something like that. And so there's some assumptions to be made here about why would you be doing that. However, those are criminal issues, right? Like if the seller would have pressed charges, in any case, the seller presses charges, there's a criminal conviction, I have something to go on. If there's allegations that are simply allegations and there's no court to back it up, I'm not the court. I can't make criminal convictions. So in this case, admitted the wrongdoing and agreed to a limited license for a period of time. We all can make assumptions about why a person's not doing medicine. And I can't go there because, again, there was no criminal conviction. So, and again, these are two cases where there's implications of other things going on. The first case, there's alcohol addiction was alluded to. All right, so one more. I think I'm time. Revocation. So occasionally we will go right to revocation. And I'm thinking of an example recently where there's a property manager and we also had to go through a court-ordered receivership. A receivership is when we have such concern about the financial health of this property manager. Either they're taking funds or it's so poorly managed. We will go to the courts and ask for someone to take over the business. It's happened once under my watch, and it had been so long that we had to refigure out our process. It doesn't have to be but in this case, the financing was so poorly handled, and the property manager was taking off of the funds that we had to get involved. First violation, well, there's actually a series of complaints from multiple property owners all at the same time, clearly taking funds. So we revoked the license, have a receivership, again, right to revocation. So in that case, we bypassed the progressive disciplinary process entirely. Yeah. Another one was here's what we're doing. We are proposing to revoke a license for a property manager. He had scheduled to go to a hearing. He's one of those that withdrew right before the hearing. He withdrew from the hearing and said in his voicemail to the DOJ, "I'm shutting down my business." So because he withdrew from the hearing and said he's shutting down the business, his license wasn't active. That does not stop our process because the complaint came in while he was licensed. And as an inactive license, if there's no discipline, he can simply reopen whenever he wants to, or get a license in a different occupation. So we went through with our proposed administrative action to revoke. It didn't matter that he closed his business. It didn't matter that he withdrew his hearing. We still could finish our process. So we went ahead as soon as we got that voicemail. We're like, okay, we'll proceed with the revocation. They issued the revocation, and I had a voicemail that I don't think I've ever had so many F-bombs in a voicemail in my life. Because he just said how stupid we all were, how no one knew what they were doing, how dare you have no concept. It's just, just a series of profanities. But now that administrative action is on file, if he tries to get licensed in another jurisdiction in real estate or a different occupation, he'll probably have to disclose that his license had been revoked by another regulatory agency. So it's really important that we follow our process to completion, even though either ghost us or just close down the business. We still follow our process. So with that, I'm actually at 55 minutes. So thank you for obliging me. Any questions, comments, feedback, whatever? The suspension, the case I gave example, I think that was I think it was 60 days. Yeah, 60 days. I think we've only issued 30 and 60 since I started. Revocations forever, yeah. We have had a few that didn't show up here where they surrendered their license and then agreed never to reapply. That's a very rare instance. Yes.
At what point in the process, if any, is a licensee's principal broker copied on the process?
We notify them up front. I'll double check that. That process may have changed. I don't want to tell you wrong, but I'll shoot a message to Kevin. And so, yeah. Yes. Well, the question was,
At what point in the process, if any, if the licensee has a complaint against them, is their principal broker?
yeah, is the principal broker notified of a complaint? I just want to restate the question. Here. Yeah, go ahead and back.
So here in Bend, the city recently is requiring a new step for the seller to sell a home starting July 1st. The homeowners court, I think everybody's familiar with that. Early in that process last year, when the committee was going through and kind of putting their thought process together on that, they were talking about if that requirement passes and the seller does not go through with it, can there be some kind of a reprimand for the selling agent? And ultimately, it came down to, because of the existence of you guys, really the city has very limited ability on what they can do, which is why they ultimately decided for a code compliance against the seller. But I'm kind of curious, like, this is just one example, and who knows what the future holds, but in those, where does that boundary lie in what the city can require versus what the agency requires?
Yeah, so we can only require what's in statute.
Okay.
And there's relatively little in the statute about what must be in a transaction document. We have must have the price and the termination date, things like that. The rest of it's kind of on the industry to develop those standards. Yeah. Now, if there was a complaint that came in that it wasn't obtained and wasn't disclosed, and there's some kind of failure in the process, a consumer can complain against a licensee that I wasn't given my home. Was it a home entry score?
Home owner's court,
Yeah, we had that. I don't know.
Sure.
Yeah, they could complain that they didn't get all the necessary documents required by statute,
But so when you say required by statute, does that include city statutes as well?
I should have said by statute. Required in the transaction, like it's below the standard of care. If the standard is you must have that in the marketplace, I should have used that phrase, below the standard of care.
But who decides, like, in that marketplace? Does the city or the state?
Yeah, I'm trying to think how, I think Portland's ordinance was, they could issue a fine themselves. We would just stay out of it, because it's not our jurisdiction. I don't know what Ben is doing.
It's a fine against the ultimate seller of the home ultimately, and I don't think they ever really figured out anything that they could go against the actual agent for.
Yeah.
But, you know, who knows what the future holds, and if somebody ever were to try that again, it's not with the agency. I'm kind of curious where that line is.
I'd have to really draw a straight line between what the agent did and if it violates one of those
Sure.
15 reasons. Yeah. So I don't have an answer for you yet. Yes, go ahead.
Is there a time limitation between the time of the incident and someone chooses to complain?
The question is there a timeline between the incident and not generally. I mean, there is a record keeping requirement that exists. So if we have a really low complaint and the licensee no longer have to keep those records, it'd be hard for us to move in that case. Anything else? Well, thank you, everybody. Thanks for obliging my horse voice is going on now. Yeah, thank you, everybody. Really appreciate it.
Thanks, Commissioner, appreciate it. Again, we're Deschutes Title, your locally owned and operated company. See a lot of familiar faces out there. You've been working with us. Thank you. Really appreciate it. If not, I encourage you to talk to one of us. Got 3 locations here in Deschutes County, LaPine, Bend, and Redmond, and a new location in St. Helens, Oregon, which is in Columbia County, just outside of Portland. We will get certificates to you by Tuesday, and hope you appreciate the class and have a good day.